Hi, my name is Toby Oxholm, and I'm the founder and executive director of the Pennsylvania Pardon Project. Um, what I'm going to be doing today is giving an overview to elected officials about the pardon process in Pennsylvania and the issues that are remaining on the table that we as a community have to address. I really want to thank Representative Andre Carroll of the 201st for inviting me to do this. He was elected in a special election this past November, and I'm just thrilled that within his first 6 months in office, he's trying to figure out how to get the elimination of criminal records and pardons onto what I'm sure is an extensive agenda. I plan to go over about 6 or 7 things today. I'm going to start off with a rap sheet. Not everybody knows what one is or what one looks like, and explain the difference between pardons, expungements, and clean slate. Then I'm going to talk about why pardons are important and why everybody is beginning to understand that pardons are important. I'm going to jump into the law of pardons. It's Pennsylvania constitutional law, not just what judges decide. It's written in the Constitution since the 1870s. I'm going to talk about the process of the steps to pardon. I'm going to quickly look at the application. And then I'm going to go on to, all right, what's on the agenda today? What's left to do? How can we capitalize on the many reforms that were made under the leadership of the Lieutenant Governor John Fetterman? So with that introduction, I want to start off by sharing uh, this document, which is an actual court record. This was available online, and I'm going to show you how to find it online. It has in the upper left, where I blacked out, the name of the person and his address, and the aliases, or the other names by which he was known, including some misspellings of his name, where his records may show up. And I want to show you this because the criminal record is extensive and it is permanent. So if you look at this guy, if you were an HR person or a loan officer in a bank or a landlord of a building where this person was trying to get an apartment, or an admissions officer at a university, it'll start off with, let's see, these are closed cases: possession of a weapon, aggravated assault, recklessly endangering, harassment, physical. All right, you're on page 1. You're going to do any business with this guy? Let's assume you have 20 people in line, and other people you can go to. Okay, there's intentional manufacturing, there's acquisition of possession of controlled substances, manufacturing, delivery of possession, all this kind of stuff. Uh, and it goes on for page after page after page. Reckless driving, um, all these things where if you go down, he's got 7 pages. But once you know how to read a court record, a rap sheet like this, you really what you have to start looking at is the right-hand side. And if I can increase the side a little bit, I don't know if you can see it any better, but if you look on the right side, it says things like held for court. That's not a disposition. Dismissed, LOE, lack of evidence. Dismissed, LOP, lack of prosecution. Not guilty, held for court, dismissed, LOE, withdrawn, withdrawn, withdrawn. Look at all those withdrawns. And these are firearms, mischief, dismissed, LOP, dismissed, withdrawn, withdrawn. All right, guilty in 2009 of a misdemeanor of intentional possession with a controlled substance. So we've gone through page after page after page after page of just how bad this guy is, when he ends up having only 2 convictions in his whole record, and everything else was dismissed. And I just want to show you now where you go to find this record. I hope you can see it's the Unified Judicial System portal. If you go into Google and say criminal records in Pennsylvania, you will get to this page. And this is how much you need to know in order to find someone's criminal record. Search by, you use the arrow and you do, a second, I can't see it because of other things. You do participant name. You scroll down a little bit, you see there are only 2 things that are starred here: participant last name and participant first name. So I'm going to use the name of someone who has agreed to use, I can use his name. and that is Suja Moore, who is the director and producer of the film Pardon Me. If you haven't seen it, you must see it, and I'll show you how to get it. But first name, last name, Suja Moore, and you go down here and you want the criminal docket. That's all you need. Now, if you're looking for the criminal record of John Smith or John Doe, you'd be amazed how many people in Pennsylvania have the name of somebody else. So that's when you would put in the date of birth. But oftentimes you don't need to do it. And then you just hit the search. And then you come down with Suja Moore's criminal record. On the right-hand side, you'll see a block with a D in it and a courthouse. The courthouse, if you click on it, is called the court summary. And the court summary is there when it shows up. Please show up. There it is. That's exactly what we were just looking at, right? And it lists all the different things where he was charged. Here's something that was dismissed, held for court, held for court, held for court, dismissed, held for court, held for court, held for court. So all of that stuff, if he were eligible for clean slate, which he's not because he committed a crime of violence, that could be invisible. But police could see all these different things, okay? But this is how easy it is to find the criminal record for somebody. This is why it's super important for trying to figure out how do you get rid of a criminal record? Because people are using them every day to stop other people from getting apartments, loans, mortgages, admissions to colleges, financial aid, serving as a guardian for minors or as for your parents who are elderly. The number of things criminal records exclude you from are so many that the medical profession is causing them a major cause of public health, a determinant of public health. And the United Way has said that removing criminal records is critical to eliminating intergenerational poverty. This is a report by the Economy League, Pardons as an Economic and Development Strategy. And in it, gives a report of their study of 10 years of people who applied for and received pardons and the economic impact of their just receiving a pardon and being able to pursue their potentials and getting the jobs that bring back more money and better benefits for their families. And it estimated $16.5 million just by the governor signing his name. My organization, the Philadelphia Lawyers for Social Equity, looked at those same 10 years worth of data, not just the 1,000 people who got the pardons, but the 3,000 who applied, and did a recidivism study. Helped by a number of law firms in Philadelphia who volunteered, we were able to demonstrate case by case, going through everybody's record, just the way I explained it here, showing the recidivism of these folks. And it was extraordinarily low. And on this website, you're also going to see quotes from the Attorney General, Josh Shapiro, encouraging more pardons faster, as long as public safety was taken care of. The Secretary of the Department of Labor and Industry saying the same things. The head of the Workforce Development Board saying the same thing, more pardons faster. The Chief Executive Officer of Pardons for Work saying, we can work all we want on getting somebody for a next job, but if they have a criminal record, there is nothing we can do because they're not going to get hired. So this is the kind of thing that is out there right now that we are battling with. Now, I should also say that the Workforce Development Board itself has now come in more than twice with recommendations. This first one, again, Representative, if you can't see it, let me know, August 12th, 2020, recommending that increase the capacity of the Board of Pardons to both decrease the amount of time for an application to be considered and to increase the number of individuals who can have their pardons heard within a year. It followed up in 2021 with a recommendation that the Commonwealth should take all requisite steps, including, if necessary, promulgating new regulations to ensure the prompt review within 1 year by the Board of Pardons of all applicants for pardon from Pennsylvanians who completed their sentence 5 or more years ago on convictions that did not include crimes of violence and who have remained arrest-free ever since. So in the fall of 2021, the Workforce Development Board is saying, We need more workers in our communities. We need to let people get back to work. Let these people out from under their criminal backgrounds, their convictions, when they have completed their sentences and lived among us as neighbors for a long time. And that's what a pardon is. It is not letting somebody out of prison. It is not letting somebody off parole. It is not letting somebody off probation. In Pennsylvania, you can only get a pardon if you have completed your sentence and can prove that you're going to be a good boy or girl, because no longer under the threat of getting thrown back into prison, but just because you're doing it, you're proving it. Every year you finish your sentence and don't have these carceral controls hanging over your head is another year proving you can make it. And so many of the convictions out there are due to drugs, the opioid epidemic. It's a scourge on our entire state. And here's the thing. While a judge can expunge some things from a criminal record, and expunge means erase, all a judge can expunge by him or herself is non-conviction data, all those withdrawns, held for court, non-prost, whatever it might be. You can get rid of all that stuff. There's a hearing with the district attorney. It goes before the judge. The judge thinks about it and makes a decision. They could also expunge minor penalties, summary offenses, public intoxication, public urination after 5 years. But anything that's ended up in a conviction for a misdemeanor or a felony, even if it was plea bargained and 90% or more of the criminal prosecutions end with a plea bargain, they cannot be expunged by a judge unless and until it goes to the governor and a pardon is issued. So here's what's going on in the law of pardons. And I promise not to bore you with the law, but you have to know the bottom line. Start off. This is Pennsylvania Constitution. Inherent right of mankind, acquiring, possession, and protecting property and reputation. Right? And this is supposed to be inviolate. And in Article 5 of the Constitution, we lay out how somebody goes about getting rid of a criminal record. And ever since the 1870s, you have to go through a gatekeeper called the Board of Pardons. And what it does is it says how you do this. You have to have a public hearing upon due notice. Okay? That's it. And it has to be a voted majority for a pardon unless the offender is still serving a conviction. Because, look, the governor can pardon anyone they want, but you have to get through this Board of Pardons. So for most everybody, those living in our communities who have finished their sentence, they need 3 votes from the Board of Pardons. And the Constitution even specifies who they are: Lieutenant Governor, the Attorney General, and 3 members appointed by the governor with the consent of a majority of the members of the Senate for terms of 6 years. They have to be residents of Pennsylvania. One is a crime victim, one is a corrections expert, and the third is a doctor of medicine, psychiatrist, or psychologist. Right? So that's your 5 people who sit on the Board of Pardons. And this is a constitutional agency. So it's really important to know what its powers are. Power cannot be restricted or operation limited by legislation. So this can't, the legislature can't pass a law saying, no, you can't do this. Can't do it. This is a power of the governor. It's another one. What happens when you get it? It completely frees the offender from the control of the state. It erases any history of the person ever having committed the crime. And this is something that from this moment forward, from the moment of the pardon forward, the former criminal has to be completed as the innocent, as if he had never committed the offense. Okay? And the court decided Supreme Court of Pennsylvania decided back in 1987 that if the governor pardons, the court must expunge the record. And thanks to the efforts of the legislature, it used to be you had to go to court, file a petition, have a hearing, goes to the judge. Judge can't do anything. Judge grants it. No, whatever. You have to get a lawyer and do all this stuff. For about 2 years now, the process is once the governor signs it, the governor sends report over to the administrative office of the Pennsylvania courts, and the court is responsible right then and there to expunge without any more hearings. This was a terrific change worked by, started in the Senate Judiciary Committee. There is no constitutional right to clemency. And for that reason, only minimal due process protections apply in the executive consideration process. Okay? And the examples are few when you're just thinking. There's a citation to the US Supreme Court. Maybe if one of these people, the 5 members of the Board of Pardon, flipped a coin to decide whether to grant clemency or recommend clemency, or where the state arbitrarily denies somebody, maybe then. But it's a really low bar. So the idea that the legislature can tell the Board of Pardons what to do, it's remote. That said, the legislature did pass a bill protecting the rights of victims, and it said to the Board of Pardons, you cannot hold hearings less than 60 days after you decided to grant this person a hearing, that notice must is doing that role. Now, legally, did the General Assembly have the power, the constitutional power, to force that on the board? Probably not. But what difference? It was a smart thing to do. It's now the law, and it is what the Board of Pardons is doing. And so this kind of highlights the interaction between the legislature and the board. The legislature can have good ideas. It can pass a law that says this, that, or the other. And if it's instructing the Board of Pardons to do something, you're not going to be able to enforce it, probably. But if it's a good idea, it's something that will get implemented because the board itself will decide, yeah, that's a good idea, and we'll change our behaviors accordingly. All right, so now I wanted to give you a sense of what this pardon process is. The record review is done by the organization or the coach. Sends in the application, which is still done by mail, but the Board of Pardons is computerizing its access, and the idea is to get that system up and running over the internet by the end of the year. Now, a lot of folks don't have access to good, reliable internet, and some people are old like me and can't use the internet for this stuff. So my hope is that the board will continue to accept paper ballots, paper applications for a while. After they've accepted it, the investigation is conducted by the Department of Corrections, and the Department of Corrections assigns it to a parole auditor, and the parole auditor goes out and talks to the victim, the judge, the DA. The DA and the judge are also sent letters saying, if you have any input, please send it to us as a matter of routine and as a matter of Pennsylvania code. The auditor will also talk to the applicant, ask a lot of questions, and then summarize everything in a report that he or she sends off to the Board of Pardons. The secretary that makes copies sends it to the 5 members of the Board of Pardons. All that was called the present status interview. Then the board decides, okay, what happens? What do we do with this? Well, the board has to consider whether to grant the individual the public hearing that the Constitution requires. That is called a merit review. They decide who merits the hearing. They get together. It's a public meeting. They vote. They call a name. They vote yes, yes, no, yes, no. They need 2 votes to get to the public hearing. Again, this is for pardon applicants, for people who have completed their sentences. 2 votes to get to the hearing. Then there's a public hearing, and it's scheduled 2 to 5 months later. Public hearing is also held on the same webcast. You punch in and you can watch. These hearings used to be done in the Supreme Courtroom in Harrisburg, meaning that if you lived up in Erie or in Philly or up in Scranton or down in Washington County, you had to drive, take off from work, get a hotel, spend the night, go sit in the courtroom for a day, all for your 15 minutes. Now it's on by Zoom. There's a public hearing. The 5 people get to ask any question they want. There are no restrictions on the questions. And again, there's no due process rights. The applicant answers the questions. After 28 or so of the people, it's about 24 people in the morning sessions, 24 people in the afternoon. In the middle, the board will take a break. They'll come back and they'll vote right then and there. And if you need 3 votes to get to the governor, just 3. If they recommend to the governor, it leaves their desk, offices, goes over to the governor, and the governor makes a decision, yes or no. The applications, 80%, 82% of the people going before the Board of Pardons at their hearings are being recommended to the governor. These are good people who have been proven to turn their lives around. 82. And it's now taking 6 years from application to the hearing. And they vote, and then they send it over to the governor, and our governor is taking another year before he gets to them. So the process is really simple: application, investigation, merit review, hearing, decision by the governor. That's it. Really simple. It's free. Now, if somebody gets denied, they can reapply. They have to wait a year, but they can reapply again. And if they get denied a second time, they have to wait 2 years and they can apply again. So all you're doing is, if you apply too soon, you haven't been out in the community long enough, you haven't demonstrated you're a good community member, you haven't demonstrated you have constraints on you, or you've got your alcohol or addictions or drug addictions under control, whatever, if you haven't fully documented them so you could prove them and you get denied, okay, keep working on it, come on back. And the fact that you didn't get it the first time is not a bar to you getting recommended the second time. There are a number of different objectives that the legislation, the General Assembly can do, that the Board of Pardons can do, that the executive, the governor can do. One thing for sure is to obtain adequate funding for the entire pardon system. The Board of Pardons finally has a really good staff. They have 12 people in their staff, 8 of whom work on pardons. They are getting through the process. They are cutting down on the backlog. Backlog is still 1,200 applications, and they're receiving over 2,000 a year. But they're handling that. What happens is it goes over to the Department of Corrections. There aren't enough parole auditors to do the investigation. Then it goes to the Office of Victims Advocate. They don't have enough people to try to track down where these victims are, counsel them, and find out what they want to do. And here's the worst thing. It comes back to the Board of Pardons, these 5 people. 3 of them are appointed by the governor with the consent of the Senate for 6-year terms. They are paid for handling 2,000 cases a year, $22,000 a year. It's the lowest amount paid to any administrative board in Pennsylvania, statutory administrative board. It's way less than what it ought to be for the amount of work they do and the importance of the work they do. That's the kind of reform that needs to be made. And if the legislature were going to give more money, they could surely say, and we expect you to have more hearings because you're getting paid 5 times more. Now, maybe they couldn't force them to, but with that much money, they would be doing it. There are other things in here too. The Senate will have to approve the appointment of a new medical expert. That comes up in November when the current one's term expires. Changing the expungement law that was effective in June of 2023, right now it's going to be applied forward. How about making that law apply backwards? Because only 30% of the people getting a pardon actually ended up going to court and getting one. So their records are wrong. They got pardoned. They're still a criminal in the eyes of Google and the internet. Providing legal immunity for employers who hire those with criminal records. So many employers are afraid, or rather their HR directors are afraid of hiring people with criminal records because they might get sued. There's an easy fix for that. You know, there are Good Samaritan laws already on the books. Adding hiring somebody with a criminal record to someone who is protected by the law from liability for just hiring that person makes all the sense in the world. If somebody's driving your truck with a criminal record and they hit somebody or something, they're going to be liable for hitting somebody. But we couldn't be able to file a lawsuit against the employer saying you shouldn't have hired this guy. And the last one is these pardon projects around the state, all volunteers, handling lots of people, lots of applications, lots of coaches. It's unsustainable as a business model to have volunteers responsible for all that. So you could fund them, give $10,000 for a pardon project, make it a matching grant to be matched by the local United Way or something. But because if the legislature is investing in these projects, United Ways will follow. Individual donors will follow, because then somebody will have validated it. So those are the kinds of things that are on the agenda now for action, By legislative, the pardons board is make things more transparent, more accountable, review more pardon applications each year, double the numbers, excuse from hearings more applicants. If you got 5 votes at the merit review, why do you need to have a hearing on that again? Expand expedited review, give the secretary power to deny, to reject meritless pardon applications. Look, if she rejects them and they want to appeal, let them appeal. But then it'll be appeal on the merits, and if they're wrong, they have to wait another year. Okay, no problem. Speed up the decisions by the governor. And then do what we can to encourage more pardon project, more pardon coaches, and all those types of things. So there are lots of different things that legislators can do to help, that individuals can do to help. We have accomplished so much together that my hope is that keeping this going, keeping these reforms going, can take these 2,000 applications a year, keep current with them, get them to the hearings, and get them their pardons faster so they can get out into the community pursuing their potential the way they should, to benefit all of us. And if anyone else watching this would be interested in seeing all the different things I referred to, just write me. It's papardonproject@gmail.com. Easy to get to me. And my name
Got
again
you.
is Toby Oxholm. Yep.